everyone. Welcome to our webinar, which I'm so glad to be moderating. My name is Cristina Mastrobuono. I am the Vice President of the Brazilian branch from the Charter Institute of Arbitrators. The CIArb is a centennial institution that provides education and training for arbitrators, mediators, and adjudicators, aiming excellence in the practice of alternative dispute resolution. It has over 17,000 members across 149 countries. It's a UK-registered nonprofit organization with 42 branches, and in Brazil, we are proudly one of them. Together with Cesar Pereira, I am coordinating these 2 days of webinars to discuss the issues of the Vis Moot and Vis Moot problem of this year. Our intent is to provide for the Vis Moot community a full analysis of the problem, but we do not intend to provide you the solution of the case, even because the nature of the competition is the arguing, the legal reasoning, the logic of the presentation. There is no right or wrong answer in this case. We will start today debating the procedural issues, and next Monday, Cesar, with another panel with other speakers, would be considering the substantive issues of the case. I want to start thanking our panelists for accepting the invitation and giving their time for our debate. I also want to thank Canal Arbitragem, our media partner, for the support. We have the presence today of Alicja Zielinska-Eisen. She's an LLM, a Polish qualified advocate, and an off-counsel at Moderators, a highly specialized law firm focused on international dispute resolution, primarily related to Central and Eastern Europe. She's combining her attorney practice with an academic career as a lecturer and academic coordinator for the IDR LLM at Humbold Universität to Berlin in Germany. Alicya's involvement in the legal realm goes beyond her practice. Having participated in moot court competitions herself, she has taken on roles as a mentor, coach, and arbitrator for numerous moot court teams. She's also an avid supporter of the Moot Alumni Association, having served as secretary and vice president of the board, and currently holds the position of co-chair for conferences and events. In addition, she's an active member of the Arbitration Commission of ICC Poland, and serves as the ICC IAAF representative for Europe in the current term. We have also Bernard Potsch. Bernard is a Brazilian lawyer. He's PhD in international law and currently partner at Batista Martins Advogados in Brazil. He's author of books and articles on commercial and labor arbitration, civil law, international trade, and international law. And he's also a fellow of the Charter Institute of Arbitrators. Then finally, we have Lourie, who will be under the spotlights today. Dr. Lourie is a German qualified international arbitration lawyer. He leads the ICAA case management team of the ICC International Court of Arbitration, responsible for the administration of approximately 200 arbitrations, primarily in connection with Germany, Austria, Switzerland, Benelux, Scandinavia, and other European jurisdictions. Prior to joining the ICC, Greg worked as an attorney with Lourie in Paris, where he represented clients in complex international commercial and investor-state arbitration across a broad range of industries, and advised governments on issues of public international law, including sovereign and diplomatic immunities and human rights. So, our webinar today will work as follows. After my introduction, Greg will give an overview about the ICC rules regarding the issues related to the problem. I want to emphasize that he's speaking for himself and not in behalf of the ICC court. Then we have Alicja talking about the first issue, and after that, Bernard will address the issue number 2. We encourage you all to send questions through the Q&A space that I will forward to the speakers. So about the problem. As always, the Vis Moot problem refers to a very up-to-date problem in commercial activity, and this year it's about the risk of cyber attacks. It concerns a dispute in the automotive industry and the delivery of sensors produced by claimant. Claimant is Sensor X plc, and respondent is Visionic Limited. They first celebrated a framework agreement to regulate the future supply of respondent with claimant sensors. Under this agreement, 2 purchase orders were made related to this arbitration, involving the delivery of sensors, PO 9601 of 17th January 22, and the PO 15604 from the 4th of January 22. Because claimant was under a cyber attack and information about the transactions between the parties were hacked and misused, claimant did not realize that the payments were not made by respondent. The reason why that happened and the legal consequences of that will be discussed next Monday. For our purposes today, following facts are important. The arbitration proceedings under the ICC rules were originally initiated for the non-payment under purchase order number 9601. Here, respondent's defense relies on the fact that it did the payment, but to the bank account informed by the hacker. On the other hand, there also was the purchase order 15604 from the 4th of January that concerns a different sensor. In this transaction, while the first payment for the delivery was made, respondent argues that the second payment was withheld due to alleged issues with the quality of the sensors. Due to internal problems created by the cyber attack and a change of personnel, the non-payment was only discovered by claimant on the 11th September 23, only a few days after the terms of reference initiated arbitration was signed by the parties, and that occurred on the 30th August 23. Nevertheless, claimant tries to add the new payment claim to the arbitration proceeding originally initiated for the claims under the PO 9601. In case that should not be possible, he makes the auxiliary request to join the arbitration proceedings for purchase order 15604 with the existing arbitral proceeding. So as we see, issues 1 and 2 are related to the question whether the new claim under the purchase order 15604 should be added to the current arbitration, or a separate arbitration proceeding should be joined to the proceeding already initiated. So with my introduction finished, with no further talking, I hand it over to Greg. Please, Greg, you have the word.
Thank you very much. I thought so, but I did not want to jump forward and capture the floor. So first and foremost, well, thank you very much, Cristina. Thank you, Cesar, for the invitation, and also to the CIArb Brazil branch. It's a huge honor and pleasure to be here. And I could not have said it better, and Cristina, that there are clearly no right or wrong answers, but you've all done the moot and your memoranda already, so you know already that there are no wrong and right answers because you've argued it already from both sides. So with this grain of salt, please also take whatever I will say from exactly this perspective. And as Cristina already mentioned, these here are my views that I'm expressing. There by no way represent the position of the ICC, nor would we want to anticipate anything or any arguments from the competition by giving you some arguments, because what fun would it then still be? So with that said, I thought I would structure this a bit twofold. First, give you an overview of the legal framework, but I think I don't need to refer to the individual articles that are at stake here. You know that to some extent Article 6.4 relevant, although not in the main view how we usually use this, because Article 6.4 normally in the jurisprudence of the ICC court and where we encounter it is usually at the stage where a party raises jurisdictional objections when it's notified of a claim, or if it's a joinder and the additional party raises it, or maybe that's an important element, just broadly speaking, if we have a non-participating party, because what the court would always do whenever a respondent is not participating, and that happens in a non-insignificant number of cases, is to ensure that the party, while not positioned, but the party is properly accorded some due process rules, and in particular to consider whether there is an arbitration agreement that exists to bind the party to this. And that the court would do if a respondent is not participating on its own motion. And small practice point, how do we do this? Because before I joined the ICC and saw this from the perspective of an attorney practicing or also as an arbitrator, my perspective was a bit that the 6-4 decisions, or most decisions, especially those where no reasoning is provided by the ICC or the parts not requested, are basically a decision that the court takes, it looks at it, and then renders its views. In reality, this couldn't be further from truth. You know how many people work in the Secretariat? I don't have the exact number in my head, but it should be something around 70, 80 lawyers that ensure that all decisions are properly reasoned, and you can really imagine it by some way of memoranda that is provided by the Secretariat to the court, and on the basis of a very reasoned decision and one that is extensively debated at court is made. Now, let's start with Article 23 for the rules. The question, can and should the addition of a new claim to the pending arbitration be authorized by an arbitral tribunal? So the first point is, when is actually Article 23(4) triggered? And it's triggered under 2 requirements, namely, a new element introduced to a case is either presented as a new claim by a party or identified as such by the arbitral tribunal. And second, the claim falls outside of the limit of the terms of reference. Question, what is a new claim? Answer, as it always is whenever we deal with lawyers, it depends. A new claim can be a new request for relief that is potentially easy to identify. So if party requested first payment for non-performance and then requests also another payment that is for another non-performance, that seems to be rather straightforward. But on the other hand, a modification of a claim, so let's say a party introduces a new legal basis for a claim or requantifies its claim and now demands more or less, usually rather not sufficient, but as always, very much a case-by-case analysis. Second, the claim falls outside of the limit of the terms of reference, and that is, of course, a lot of space to argue. Very much a case-by-case analysis, but I would like to give you maybe some interesting perspective what it could be. Imagine the following. You have, as a party, claim for a certain amount, and you would like to introduce a second claim. You're a bit concerned that this second claim might actually not be accepted by the arbitral tribunal because it's a new claim, more or less. Let's say you're not too worried about that. But at the same time, you think, well, what about if to my present claim, which is now only, I want 100,000 euros for a breach of contract, I introduce a claim finding that the contract has been breached, and that's a declaratory relief. Would that be a new claim? Because if it's not a new claim, you could to some extent introduce this and lead to a situation where, while you can't make your monetary claim, the second monetary claim in the same arbitration, you might still benefit from it by having a declaratory relief that is extremely helpful to you in a second arbitration when bringing it. Just as a consideration for you to have. So with that, what considerations does a tribunal then actually take into account, considering that prerequisites are met, when deciding whether to admit a claim or not? As always, very much depends, but let me anticipate one point. Even if the tribunal decides to admit a claim, there is still the point about jurisdiction. It's one point that the tribunal admits a claim and says that it will hear it. It does not mean that it automatically has jurisdiction over this claim. And it's an interesting point, because if the tribunal is from the very beginning convinced that it would not have jurisdiction over this claim, well, it might also take this into consideration in deciding to exercise its discretion whether to admit a claim or not. And you need to remember that the arbitral tribunal's decision whether to admit a claim, a late claim under 24 or not, is extremely broad. It's very difficult to challenge the tribunal's decision to not admit a new claim. So jurisdiction and whether to have it or not might be a point that you would want to argue already, even though it's in principle a subsequent step to take. So jurisdiction would, at that point, what you want to argue also concern the analysis under the lex arbitrii. I can't stress this enough. Some may confuse that with the prima facie jurisdiction of the arbitral tribunal under Article 642. However, that the arbitration agreements under which those claims are made may be compatible, or that all parties to the arbitration may have agreed to those claims can be determined together, is not a requirement per se. The reason we have this in Article 642 is because we would expect that most jurisdictions actually assume that this is the right threshold, and that all jurisdictions, at least to some extent, would have this threshold. But it's by no way imperative. So the actual decision on jurisdiction by an arbitral tribunal is not under Article 642, but is exclusively under the lex arbitrii. Then let's say, what other elements would arbitral tribunal take into consideration when deciding whether to admit a claim or not, assuming the question of jurisdiction is laid aside and the tribunal either thinks that it has or correctly assumes that it will decide the jurisdiction later? Well, let's assume the principal points here are the weighting of the delay of the disruption of the proceedings on the one hand versus efficiency gains on the other hand. And in this, the elements that you can argue before the tribunal are literally unlimited. It is the stage of the proceedings that will be relevant. For example, if it is the proceedings are already at a very late stage, then the tribunal might be really unwilling to create further delay by allowing new claims. At the same time, the tribunal may think, well, wait a moment, are we producing a situation where there might be contradictory decisions and contradictory outcomes at the end? And if that is the case, the tribunal may think that it's better to admit a claim at that point rather than risk that in a second arbitration, contradictory decisions arise. We'll speak a bit more about this later, but with this, let's move actually to the point of consolidation, because as you will see, some of the points that we'll speak will be comparable. So what and how does consolidation under Article 10 work? There are three options for consolidation. And for those of you who like video games, I would like to call them easy, medium, and hard version. The first one is the parties simply agree to consolidation. That's the easy version. There's little much to consider. If the parties expressly agree, and it needs to be an express agreement, then this is it. At the same time, moving to the second point is all the claims are made under the same arbitration agreement. That, let's say, is the medium difficulty. Here to notice in particular that only if it is the same agreement, meaning that the same contracts, so not identical agreements in different contracts, but the actual same duration agreement, then this alternative applies. You will see that there's now, with the revision in the 2021 rules, the distinction is made between that all claims to arbitration are made under the same arbitration agreement or agreements. That is not to mean that agreements in different contracts would suffice. Rather, it's a situation where you have arbitration A, which is based not only on one arbitration agreement, but on 3 arbitration agreements, which can very much happen. And then you have the same arbitration B that is equally based on these very same 3 arbitration agreements in the same contract, the identical document, so to say. And that is just a clarification that it does not necessarily need to be one. And Article 10b, second alternative, is not excluded just because you are relying on multiple arbitration agreements. So with this, let's move to the hard version. And that is that the claims in the arbitration are not made under the same arbitration agreement or agreements, but the arbitrations are between the same parties. The disputes in the arbitration arise in connection with the same legal relationship, and the court finds that the arbitration agreements are compatible. As said, all these requirements need to be met cumulatively. What does it mean? So let's start with arbitration need to be between the same parties. That means it is a requirement that it's between the identical parties. Different parties related or part of the same conglomerate or whichever other connection they may have is insufficient. So we've seen sometimes cases where, well, it's not the same party, but it's a wholly owned subsidiary or similar, or it's a branch which may not even have legal personality under certain laws, whatever. All of this is absolutely not sufficient. It needs to be completely identical. Also, for that reason to note, the principles of prima facie jurisdiction under Article 6.4, so where the court would generally consider what I mentioned before, that a party should, whether the dispute should continue against a party in case of a joiner, for example, that is not directly mentioned in the arbitration agreement, these principles do not apply. They have a completely different consideration behind them, namely whether under certain concepts such as piercing the corporate veil or a group of companies, there would be a way to extend the arbitration agreement, which is then for the arbitral tribunal to resolve. But this is a completely different principle compared to the present requirement of identical parties. Let me anticipate and take the third requirement second. The arbitration agreements need to be compatible. So when is that the case? Arbitration agreements are obviously compatible when they're identical. That's clear. Arbitration agreements are incompatible if they're not identical in the relevant criteria. What are these? So let's say, for example, number of arbitrators. You have you want to consolidate an arbitration, but one provides, as the express number, 1 arbitrator, the other one provides 3. Then let's consider different methods of constituting the arbitral tribunal, and the parties do not agree to deviate on one or another. You might have an issue. Seat of arbitration. Different cities in the same country are a problem. If it's the same seat, if it's the same city, that's fine. But the problem arises from the fact, if there are different cities, that different courts would be competent for one or the other arbitration to hear, for example, interim measures or any other form of court assistance, or for setting aside proceedings. And for that, different cities as such are absolutely reason to not consolidate. Different time limits for rendering an award might be also another. But let me clarify one important point. Not necessarily incompatible, though, is it if the court can fix the differences. So, for example, you have one arbitration agreement that provides for 1 arbitrator and or 3 arbitrators, and the other arbitration agreement, it is not determined how many arbitrators. Here, potentially, the court could decide to fix the number to make it compatible. Whether it will do it is a different question in a case-by-case analysis, but it's not per se incompatible if it's open and can be cured by cured, can be made compatible, cured is the wrong word, by the court's decision. The same applies also for seat. If a seat is not indicated at all, if in one arbitration agreement the seat is expressly indicated and the other one not indicated at all, or for example, it's indicated in a way that would require concretization by the court, such as a country is indicated, but no city is indicated. That as well falls usually within the category that is not per se incompatible, but subject to case-by-case analysis. And lastly, in the interest of time, the point that I want to mention is also the same legal relationship. Whether the same legal relationship is there or not is, from the court's jurisprudence, primarily a matter of having or being part of the same economic transaction. So you can imagine this, for example, to be separate elements of one large construction project between the same parties. What you're probably all interested is to hear whether in a long-term relationship with a framework agreement and several individual transactions, that would lead to a same legal relationship. But here I would unfortunately just leave you by saying that it would depend. So I will conclude here to say that think about one more point. Even if all these prerequisites on consolidation are met, the result is still that the court has discretion. The court does not have to consolidate. And neither to the extent that it might be a situation where an arbitral tribunal decides on consolidation, neither must it. And this is where we turn to the same points that we heard already under Article 23.4, namely why the court should do it. And you can discuss all these points from efficiency, avoiding contradictory decisions, etc. very well also here. I'm looking forward to your questions. Very much looking forward to discuss it. Hope it was helpful, and most of all, wish you all good luck in the competition. Thank you.
Thank you very much, Greg. Are you hearing me now and seeing me? I had some connection problems. I hope it's good right now. So thank you very much for your thorough explanation about the rules, about all the situations. I could see some of them in our case. I could think about some arguments that we could already be using. But well, let's, I do not need questions right now. Let's go on and hear Alicia's presentation about issue number 1.
Happily. Thank you very much, Cristina, for the kind introduction and for having me here today. And welcome to all the team members and coaches that are listening in. I will join Greg in saying not only thank you, but also that I hope that you will share some questions to us that we will be able to engage in a discussion. That's why we are here for, because I'm sure the teams already research every possible piece of article and a case law that is available on the planet Earth, on both the issue of a new/added claim as well as a consolidation, be it under the ICC rules or by using a comparative law standard and comparing it to other arbitral rules and lex arbitri. So just to kick off the discussion on the procedural issues of this year problem, I wanted to open with an easy question. Every year, or almost every year, the Vis Moot problem presents us with a jurisdictional issue. Do we have that issue this year? It looks like not, because the respondent per se doesn't challenge the jurisdiction of the tribunal. However, the big question is, which arbitration agreement is the basis for the tribunal jurisdiction? And here the parties' positions differ. And we do have as many as 3 clauses to choose from, which might have a different status, and the parties might argue differently on whether which of the clause is the prevailing clause, which of the clauses are valid and which are not, and for what reason. However, I would like to leave this issue aside, because I think for the teams, there will be a big choice to make whether to argue on the arbitration agreement and the one that is forming the basis of the argument up front, or only use it to substantiate the arguments on the added claim / on the consolidation. So I will leave it up to the teams and the coaches to make that executive decision how to argue that. But per se, we do not have the specific traditional jurisdictional issue where the respondent is objecting to the jurisdiction of the tribunal. The respondent is objecting to hearing both of the claims, the one under the Order 9601 and the one under, or the new claim under the Order 15604 together in a single arbitration. And now I wanted to go back to a point that Greg made, that is what it actually means to make a new claim. And having reviewed some memoranda on the drafting stage by the team, I've noticed that some teams were referring to the new claim as added claim and that a claim should be added. And some teams refer to a new claim. So is there a distinction? And if there is a distinction, does it has a legal meaning, that distinction? And here I wanted to leave you with two observations. First one goes to the timing. And let's start with something arguably easier. So the big question in arbitration is which claims can be put forward by the claimant. And of course, it is the claimant that formulates the claims which it seeks to put forward in an arbitration. So in our case, would the respondent arguments be any different if the claimant already in the request for arbitration would have put both claims at the same time together properly? Or does the respondent position changes only because of the specific wording and the fact that the terms of reference has already been concluded? So I think that is an important distinction for you, for the teams to make and understand what is the actual scope of the arbitration agreement on which the jurisdiction of the tribunal in a given case, and we already have a constituted arbitral tribunal, which arbitration agreement forms the basis, and correspondingly, what is the scope of the arbitration agreement under which submission of the claims was agreed by the party. Because here, of course, the claimant commencing the arbitration has an upper hand. It is the claimant that decides on how to design the request for arbitration and how to describe the mandatory elements of the request for arbitration, which are provided under the ICC rules, what the request for arbitration should contain. Correspondingly, it is up to the respondent to decide which claims, counterclaim, set of claims, can the respondent put forward within the given arbitration. The second group of questions revolves around the question about the time when the tribunal is already constituted and the proceedings are already pending. Can the claimant and the respondent subsequently add new claims, modify claims, or revise claims otherwise? And here, bringing this theoretical consideration into our Vis Moot case this year, I wanted to leave you with three leading questions that I think will be core for addressing in the oral argument. First, and before we go into the strictly legal arguments, what is the claimant's interest in bringing the new claim into pending arbitration? Again, what is the claimant's interest in bringing the new claim into the pending arbitration? So the claimant commenced the arbitration, participated in the conclusion of the terms of reference, and a few days later adds arguably a new claim. What are claimant interests? I think that will be very interesting for the arbitrators to hear, because of course they will want to understand why claimant chose, being in the driver's seat, why the claimant chose to proceed in such a manner where the two claims are separated. And from the fact of the case, we know that arguably the claimant was not aware at the time when commencing the arbitration / even before when submitting the request for arbitration of the new claim that was later, that the claimant wishes to add. That of course will wait on the assessment of the tribunal. Second question is already going into the legal arguments. can a new claim be added in principle? And what are the legal basis and what are the prerequisites for adding a new claim? And here we've heard Greg explaining us the meaning of Article 23, Section 4 of the ICC rules. And I may quote, even though I'm sure all the Mooties already know it by heart, that after the terms of reference have been signed, no party shall make new claims which fall outside the limits of the terms of reference unless it has been authorized to do so by the arbitral tribunal. So we have three elements that I wanted to underline that probably will be something that the tribunals will be interested to ask questions about. First, it's the timing element. We are already not arguing, but looking at the date, we are after the signing of the terms of reference by the parties, but not much, just a few days, but still after the signing of the terms of reference. No party shall make any new claims which fall outside the limit of the terms of reference. Thus, the new claim falls outside of the limits of the terms of reference. And from the case file, we know that there is a specific wording that the parties sign up to with regards to the terms of reference that are quoted in the case file that probably will be central of the attention of some of arguments if the students choose to argue that the new claim is not actually a new claim. It might be a revision of the claims that very well fit within the limits of the terms of reference, that it is something that the parties anticipated in the terms of reference to do. This is one way to put forward the arguments. There is a second element that allows admission of a new claim that is with the tribunal authorization. And here Article 23, Section 4 provides us also with the elements that the tribunal should consider. And these are the nature of such claims, the stage of arbitration, and we have the ultimate broad clause and any other relevant circumstances. What are those circumstances and are they met? So that goes to the second question. And now the third one is who, when, and how, that is in what form, decides on including a new claim, assuming the tribunal authorization is needed. So we are in the second leg of the Article 23, Section 4 of the ICC. And with that in mind, I wanted to also bring up the meaning of the first, the parties' consent and what the parties anticipated in the respective arbitration agreements, as well as the selected lex arbitri here, that is the Procedural model law. The Procedural model law in principle provides for a reverse rule to ICC rules. So ICC rules says no new claims unless authorized by tribunal, and the Procedural model law provides new claims are permitted unless the tribunal thinks they are delayed or otherwise not appropriate to bring up at a later stage of the arbitration. And with that, you can look at Article 23, Section 2 of the Procedural model law, which says, unless otherwise agreed by parties, so here a red flag for you, the parties' agreement, of course, prevails, either party may amend or supplement his claim or defense during the course of arbitral proceedings, unless the arbitral tribunal consider it inappropriate to allow such amendment, having regard to the delay in making it. So kind of the concept of this provision to compare with, again, 23 Section 4 of the ICC rules, it's flipped the other way around. And the mirror-like provisions of the Procedural model law can be found in other domestic regulation. For example, the German Code of Civil Procedure, when dealing with arbitration, provides a mirror-like solution, which even though it specifically talks about amending and supplementing claims or defenses in arbitration, it is in the same way applied to making a new claims in a pending arbitration. So just a flag for you to consider what's the relation between the ICC rules on the one hand side chosen by the parties and the lex arbitri also chosen by the parties, at least under some of the arbitration agreements out of the 3 that we have as an arbitration agreement landscape provided by the Vis Moot problem authors. And that brings me to my final issue. And here I will also not want to spend too much time because the prerequisites or the elements of the tribunal discretion within which the tribunal operates to allow or not allow additional or new claim are in some degree similar to the consideration we'll need to make under the consolidation. So let me just conclude that the new or amended claim in arbitrations are not a clear-cut issue. And clearly that's how they landed as one of the Vis Moot issue, because there is so much to discuss. And the arbitral tribunal in this regard generally takes the front stage. So even if we look at Article 23, Section 4 of the ICC rules, which will be central to many arguments, not only we have a specific text of the terms of reference as concluded between the parties and the tribunal in the case at hand that we will need to look at and interpret, but also we do have the specific authorization and the scope of the tribunal discretion for the decision defined within the arbitration rules, and these are very broad. They go not only to the nature and the timing of the proceedings, so kind of efficiency consideration, but also other relevant circumstances. What is it? I might leave it back to Greg to answer what else could we find under this other relevant circumstances, but it is a pretty broad term. So on the one hand, admitting a new claim could be a fantastic tool to improve efficiency of proceedings, because as you all argued, it can save time and be time and cost efficient. But on the other hand, situation in which a claimant, especially on the claimant side, chooses to submit one claim at a different point in time as another claim that was existing at the time of request for arbitration being submitted, kind of raises a red flag in the eyes of arbitrators, because it might go into guerrilla tactics and then jeopardize the fairness of the proceedings. And in the end, the only consequence for the tribunal not admitting the new claim is that it forces the hand of the claimant to decide whether to submit and start a new arbitration proceeding. And yes, that goes with increased costs of the arbitration per se, but in the end, it is the claimant that is in a driver's seat. So maybe that is not the worst outcome possible, and tribunal can have an easy life with a clean slot arbitration and an easy way to a fast award. And with that little bit provocative thought, I will leave you for the consolidation arguments, and then very happy to engage in discussion.
Thank you very much, Alicja. Very interesting thoughts that you brought. And Bernard, I guess it's your turn now.
Thank you, Cristina. I'll try to be brief in order for us to have a fruitful discussion later. Just to begin, I would like to thank once again the CIArb Brazil branch for inviting me to this beautiful discussion together with Alicja and Greg. I believe maybe the first discussion broadcast after the delivery of the respondent memorandum. So it will be a pleasure to kickstart the discussions on the case of the Vis Moot. I'll use a brief presentation just to better guide the discussions. Let me know if you can now see it, please. Can you see it? Perfect. So, beginning. After Greg and Alicja already introduced us to several of the key topics, including topics that will be relevant to the matter of consolidation, it falls to me to dive a little bit deeper on this topic. But prior to going there, I'd like to make an initial caveat, and that is, if it was once said that all roads lead to Rome, it can be certainly said now that many roads lead to victory or prevailing the arguments in Vindobona in Vienna. So please take this initial discussion only with the intent that you had for it. That is to kickstart discussions, to give you new ideas, to discuss with your other teammates or coaches, and keep developing it until Vienna. We do not presume to have the right answer, particularly to this crowd that certainly has delved into this case much deeper than any of us. So think of this only as a way to kickstart discussions. So to begin, most likely the teams will deal with two main questions when dealing with consolidation. And that is, if the tribunal has the power to consolidate the proceedings, and this will fall under Article 41 of the Framework Agreement and Article 10 of the ICC rules. And after that, whether or not the requirements for consolidation were met, either under Article 41 of the Framework Agreement or Article 10 of the ICC rules. Of course, this does not mean that you cannot argue other issues when dealing with consolidation. For instance, it may be reasonable to argue that consolidation, if the tribunal understands that a new claim could not be added to this arbitration, allowing consolidation may be seen as a workaround for the impossibility of a new claim, and disregard what the parties have agreed on in terms of reference. These and several other arguments could also be made by the teams, but I'll focus here on those that most likely will appear during the discussions of the Vis Moot. So let's begin by whether or not the tribunal has the power to consolidate proceedings. And why does this discussion exist? Just a brief reminder. And that is because Article 41.5 of the Framework Agreement established that the arbitral tribunal of the first arbitration proceeding has the power to consolidate, while Article 10 of the ICC rules give this power to the court, the ICC court. So we are faced with a situation where the parties at the Framework Agreement agree to give this power to another entity, not to the court. And we have to see whether this choice was validly made and in order to see if the tribunal itself could analyze this issue, not the court. So the first question we have to ask when dealing whether or not the tribunal has the power to decide on consolidation is which agreements are governing this arbitration. Here, I bring to you the three possible arbitration agreements that we have in the dispute. Those in the Framework Agreement of 7 June 2019, on the Purchase Order 9601 of 17 January 2022, and those in Purchase Order A15604 from 4th January 2022. It may be argued that, for instance, in the first arbitration and the arbitration that we have now, given that claimant has argued so far under the purchase order and its arbitration agreement, respective of the fact that they mentioned the Framework Agreement in passing, that the parties may have decided to set aside Article 41.5 for an arbitration ruled by the second arbitration agreement. This means that we would not need to have this discussion. The power would be for the court to decide, and there would be no need for the arbitral tribunal to consider the requirements. However, it is important to point out that both the purchase orders mentioned at their very beginning that unless agreed otherwise, the provisions of the Framework Agreement would still apply to it. And so it could be said, on the other hand, that if the parties have not dealt specifically with consolidation when establishing these other arbitration agreements, they intended for the clause from the Framework Agreement to apply here. These are only a few of the discussions that may be had relating to which arbitration agreements should be considered for this discussion. But let us consider that the Article 41.5 of the Framework Agreement is relevant to our discussions. If this is the case, is it possible to derogate from Article 10 of the ICC rules? Have the policy validly derogated from it, or are they barred from it? There are several arguments that could be made regarding that. For instance, it may be argued that consolidation is a fundamental characteristic of ICC arbitration, particularly giving this power to the court would be a fundamental characteristic of ICC arbitration. It could also be argued, for instance, that Article 19 of the rules, when established that where the rules are silent, the parties may settle on other issues. It is giving the parties limited power to derogate further from the rules where they are not silenced, or if they are not expressly giving this power to the parties. On the other hand, it could also be said that arbitration is a being of party autonomy. So in principle, the parties could derogate from from most of the rules applicable by the arbitral institutions. And this, so you would have a restrictive reading of what is a fundamental characteristic of ICC arbitration. For instance, scholars usually say that scrutiny of awards is a fundamental characteristic of ICC arbitration, so most likely the court would not agree with setting that aside. It may refuse to administer that proceeding if that is the case. On the other hand, it could also be argued that Article 23, paragraph 4, when it gives the arbitral tribunal the power to decide on new claims, and given that the effects intended by claimant on this case with the consolidations specifically to bring these new claims to this arbitration. So Article 23, paragraph 4 may be argued to illustrate that the courts may not would not object to this to the parties giving this power to the arbitral tribunal. So of course there are many other arguments that may be made, but some that come to mind are those. However, so let's not assume that the arbitral tribunal has the power to decide on consolidation of the proceedings. If that is so, we now reach the second part, let's say, of the argument, and that is whether or not the requirements for consolidation are met in this arbitration. And the first argument that most likely we'll have to make is which requirements are applicable to this case. We have Article 41 of the Framework Agreement that establishes 3 arguments, and those are marked here. And on the other hand, we have Article 10 of the ICC rules that brings other requirements for consolidation to be possible. When the parties agreed on the Article 41.5 on consolidation, have they derogated from the requirements under the ICC rules and established new ones? Or should both the requirements be met in order for consolidation to be achieved? Maybe this could possibly be one of the first questions to be addressed by the teams. But let's assume that the requirements under Article 41 of the Framework Agreement are relevant. They are 3 requirements. The contracts need to be concluded under the Framework Agreement, the subject matter of which are related by common questions of law or fact, and the end result of the arbitration could result in conflicting awards or obligations. Just summarizing, disputes in relation to contracts under the framework. It can be argued that maybe the purchase order as standalone transactions that should be considered so for the fact of this clause. But on the other hand, they open the purchase order specifically stating that the framework agreement is somewhat relevant to it. On the subject matter related by common questions of law or fact, it could be argued, for instance, that both claims relate to have their background on whether or not form requirements under Article 15 and 40 of the Framework Agreement were waived or set aside by practice. So if the tribunal were to decide the first claim, if the proceedings were not consolidated, you could reach contradictory decisions on the matter. On the other hand, you could also say that while the claim brought under Purchase Order 9601 relates specifically to the cyber attack and whether or not there is an obligation to inform the opposing party to the other contracting party of the cyber attack in order to mitigate damages or otherwise, this second claim brought under Purchase Order 815604 would relate primarily to the non-conformity of the goods. So we do have possibilities on both hands under Article 41 Framework Agreement. 1 second. Now moving on, under requirements under Article 10 ICC rules. Most likely the first question the teams will have to face is which subparagraph of Article 10 to argue under. Article 10A, let me just put it here, 1 second. Article 10A and 10B deal with when the parties have agreed on consolidation and whether or not the arbitrations were brought on the same arbitration agreement. Although it may be a steep hill to argue that, it is possible to argue that when the respondent insisted on adding a consolidation clause to the arbitration agreement, they somewhat agreed to consolidation if the requirements were met under it. So Article 10A may be argued as a first reason for consolidation. And just to answer one of the questions I saw in Q&A, Brad can confirm this later, but in Article 10, A, B, and C, they are alternatives to each other. If the first one does not apply, you go to the second one or the third one, that you do not have to meet all the requirements of the three of the subparagraphs in order to go to consolidation, particularly because if that was the case, you would have always to have the agreement to consolidation. It would deprive Articles 10B and 10C of any relevant meaning. But under Article 10B, you could also argue, can delve into discussions of whether or not these proceedings were brought under the same arbitrations agreement, or whether or not the new claim is being brought specifically under the arbitration agreement of Purchase Order 815604. But most likely we will deal most of the time with Article 10C, which, as Greg already stated, brings three requirements. That is, they are between the same parties, and it's undisputed here that those two would be between the same parties. The disputes are in relation to the same legal relationship, and most likely this is where the meat of the arguments is more present, whether or not the purchase order really are a same economic transaction or same economic operation, whether they are even if they are connected through the framework agreement, that is not enough. You can argue that even though the framework agreement deals with matters where they are silent, purchase order one deals of LiDAR systems, other radar systems. The negotiations were not conducted by the same person in the company. So there are arguments to both ways to argue it. And on the other hand, the framework agreement may be an indication that there was an agreement between the parties that this is a same economic transaction. Finally, the arbitration agreements are to be compatible. Greg already went through this, so just to emphasize, I brought here again the arbitration agreements with possible points where they may be compatible or incompatible. All of them go to the ICC rules. All of them mention the place of arbitration in Danubia, but the purchase order 9601 mentioned Vindobona as the seat of arbitration. Would that be enough to say that they are incompatible? Would the choice of law by the parties be enough to say that they're incompatible? The framework agreement mentions the law of Danubia, while the purchase order specifically mentions the CISG. The fact that the CISG encompass the law of Danubia encompass the CISG is enough for them to be compatible. It may be argued both ways. Also, the number of arbitrators, while the framework agreement and the purchase order mention 1 or 3 arbitrators or 1 or more arbitrators, the purchase order 9601 mentions specifically 3 arbitrators. The fact that this could be fixed by the arbitral tribunal is enough for us to allow consolidation in the case at hand. And finally, and Alicia mentioned this prior, we do have, even if the requirements for consolidation are met, we do have other circumstances to consider. The circumstances under Article 10 mention particularly the arbitrators, if they have been appointed or confirmed, but maybe we can also derive from it if the characteristics of both arbitrations do not require different kinds of arbitrations, arbitrators with different specialities, while the first ones deals mainly with cybersecurity, the second one deals mainly with non-conformity. And for instance, respondent appointed Mr. Victor Clemente, who's a specialist in cybersecurity, but maybe not so much on the conformity of the goods. So it may be argued also that even if there was no arbitrator appointed in the second case, it would deprive respondent of the opportunity to properly indicate its arbitrator if the arbitration is consolidated with this arbitral tribunal. Finally, there may be some questions of efficiency to consider. The parties under item 85 of the terms of reference specifically mentioned that new claims could only be added if they led to considerable efficiency gains. Why should you not consider this for consolidation if at the end of the day, what risk claimant wants is reaching, adding a new claim through another way? So, as I said, those are only some of the possibilities of this case. I would like once again to emphasize that Vindobona is there. There are many arguments to be had. Please do not find that we do here that we are here giving answers to you. We are only posing questions and giving ideas, and it will be a pleasure discussing them with you right now. Thank you very much, and I pass the word to Cristina.
Thank you very much, Bernard. This was also very, very objective and clear presentation. And well, I strongly invite all the participants to send their questions using the Q&A area here. We already, I guess Bernard already answered one of them. Well, before going to my comments, I would like to know if one of you wants to comment on the presentation of the other. So once I saw Greg raising a hand, but it was a mistake. Okay.
Right. Exactly. No.
Okay. Well, I had some questions here. Okay. Of course, there are a lot of variables that we have to consider, considering the reality of the case, the facts, and this is, of course, Vis Moot case is one that brings peculiarities that can be used in one way or another. But generally speaking, and here I think I would like to hear Greg again, and maybe you talked about it on your presentation, but since I missed something because I was changing my spot here in the office, it's not so clear for me. So this is the question about who has the power to decide. So as I understood, when we are in consolidation, Article 10, court has the power. And after the terms of reference are signed, the parties agreed upon it, then the tribunal has the power. So there's no doubt about that. But then if we have a situation like the one in the case in which the parties gave this power to the tribunal, as in Article 41 of the framework agreement, so that the tribunal is entitled to decide about consolidation. Is it something that happens in practice? Or, so I don't know if we can speak about this kind of situation, but what happens usually in real life when something like that happens? And another question that I would like to make related to this is if this is used as a strategy by counsels, because they can try to consolidate under Article 10, court says no. Are they entitled to go to the tribunal arbitral and ask there to add a new claim in the same arbitration that is already going on? So
Yeah.
that would be.
Thank you for this excellent question. I think Bernard also already addressed it to some extent. So let me maybe take the obvious and the clear one first. So it is whenever we're speaking about additional claims, or let's say claims that are raised after the terms of reference are established, there I think we're in a territory of no doubt that that's for the arbitral tribunal. The court is hands off on this. In practice, it happens that a tribunal may, on a more informal basis, sometimes consult to hear our views, but we would always, and while we might share them, we would always clarify that that's a full discretion of the arbitral tribunal, and neither the Secretariat nor court has a standing in this. Your second question about whether we see in practice parties agreeing in the arbitration clause to consolidation being for the arbitral tribunal and not for the parties. I don't want to go too much into detail simply in the interest of the competition as well, but let's just say that it certainly happens. These arbitration clauses exist. Maybe if I may put on my counsel hat back on from having practiced, I can tell you that I've seen under various arbitral institutions frequently very sophisticated consolidation clauses, for example, that you would see in facility lending agreement is similar, where you can see that parties certainly spent a lot of time considering how exactly consolidation should work, and these were usually very well drafted. I'll leave it with that, just to say that certainly we see this, and it will be very much a case-by-case analysis, as much as Bernard already said. Your follow-up point to this, do we see that a party tries to consolidate before the court fails and moves to the arbitral tribunal? I haven't, and I would consider this quite difficult. So if you don't have because you have either under the rules, it's the court, and period. Let's say you have a arbitration clause that deviates from this principle and it's a tribunal, well then it is tribunal subject to discussion whether the clause is valid as such. But if you go back to the default position, namely that it's just the rules applicable, then there is no room for the arbitral to go to the arbitral tribunal for a decision on consolidation, I would argue.
Okay. Does someone want to make comments on that, so I can move to the questions that are being formulated here? And one is, so can ICC tribunal order consolidation instead of ICC court? I think this was already answered. Yes. If one party is arguing against consolidation, would bifurcation be possible? Wants to comment on that? Well, I guess it's depending on the case. Alicja, would you like to?
The question is, what bifurcation would you then like to have? So if you are asking for consolidation, it presupposes that you have 2, 3, 4, whatever number of proceedings that are at certain stage of being pending. And now what you want to bifurcate in the first set of proceedings, it would assume that the tribunal / the court make the decision on consolidation, so that the claims can be heard in one set of proceedings. So I think there is a procedural distinction, or like a step that is missing, that would need to be taken in order to effectively order a bifurcation. The answer would be different with a new claim. So if we are asking the tribunal to add a claim / modify a claim, then potentially a bifurcation could be solution, that we first deal with the initial claim and we leave for a second stage the new / added claim that could be procedurally contained within a single set of arbitration. So I see a distinction between the two situations. So for the one, I think theoretically you could bifurcate. The question is how this contribute to efficiency with regards to time and cost. Probably a bifurcation leads to a situation where the claims are just heard subsequently. So, but for a potential little bit of an advantage on cost, you are not achieving much. And arguably the fairness consideration with regards to the party initiating the first proceeding and the respondent in the first proceedings with regards to the original claim needs to be considered, because arguably it will have to wait for the final award on cost until the bifurcated new claim is decided on as well. And the second scenario, in which we have the consolidation situation where parallel cases are pending and the question is whether to consolidate them into the first arbitration or not. There, I think procedurally it's difficult to argue that the proceedings can be bifurcated. The indirect question can also be answered by saying that a de facto consolidation can be achieved by selecting the sale tribunal for each of the cases. So we have the same 3 arbitrators deciding on the original case, as well as the same tribunal composition is provided for the new claim pending as a separate arbitration. And then, of course, we can try to de facto bifurcate the proceedings. However, I'm not aware about the recent case law or decisions from the ICC which will allow such a de facto consolidation, whereby basically the consolidation takes place between the same parties and by means of basically appointing the same tribunal twice. And here again underline the court's role in approving the appointment of the arbitrators for the parties, and of course the presiding depends on the parties' agreement, but still the ICC court role is pretty active here. So maybe over to Greg, if that is scenario that is possible or likely to happen.
Yeah, thank you for raising it. And this is actually a good scenario. I recall cases before the court where consolidation was not possible because, let's say, for absolute incompatibility and lack of agreement with the party. So 1 versus 3 arbitrator in the different agreements, or let's take it back, 1 versus 3 would probably be even more difficult. But let's say 3 arbitrator and incompatibility because different seats, and the respondent does not agree for whatever reason. So here there have certainly been instances where the court emphasized that it would be good to have the same tribunal in place, and to the extent that this task was under the arbitration agreement within the court has appointed the same arbitral tribunals to ensure that the arbitrations can be, for example, heard together. How to organize this, that's in the end in the hands of the arbitral tribunal. But it is certainly something the court has taken in the past as an option.
Okay, thank you. We have a lot of other questions here, and one is kind of simple, but I think it's important to address to know the consequences of that, mostly related to the court. It's what is the fundamental difference between addition of a new claim and consolidation as two procedural mechanisms? And I think that goes to Greg.
Yeah, thank you. I think it's a very strict distinction. Additional of new claim mean you have an ongoing arbitration and a new claim is added to this. So you have one case, and what the tribunal will decide on is extended, provided the tribunal permits. So consolidation is a process where you have two separate arbitrations, and the court or the tribunal, whichever the situation might be, decides that they should be merged. And the way this is done, usually, save for special determinations, is that the second arbitration ceases to exist and is merged within the first arbitration. So, and that which then continues. That can have a lot of procedural consequences. So first of all, obviously the claims of both arbitrations are done in one arbitration. The question of costs, for example, you had two arbitrations, let's say, of 100 million. Now you have one arbitration of 200 million. That will lead in the first arbitration to an increase of the advance on cost. If you had a tribunal constituted in a second arbitration, that tribunal will become functus officio. It can be a reason not to consolidate, but it's not an absolute reason, as we've seen under requirements of Article 10. So there are a lot of complex consequences flowing from a consolidation, but I think the main takeaways, one is adding an additional claim, extending one case to cover more ground. The other one is merging two by virtue of making one of the two disappear and being included in the first one.
Okay, thank you. Then we have would the tribunal consider the fact that the request for authorization of a new claim has changed the procedural timetable, especially taking more time than agreed upon to render a final award for the first claim? Yes, Bernard, would you like to answer that?
This will be an issue for the first arbitration to deal with. If the arbitral tribunal found that there may be discussed whether or not consolidation or a new claim requires the parties addressing the issue, and most likely the arbitral tribunal will have to do so, it may be a consequence that maybe the procedural timetable will have to be altered to accommodate that. On the case at hand, what it seems to me is that the arbitral tribunal tried to avoid unnecessary delays for the decision of the first claim when drafting the procedural timetable. So it instructed the parties to deal with the matter of on the merits of the claim under Purchase Order 9601, while it's still discussing whether or not the claim under the other purchase order should be considered here. But I don't know if this would impact on the decision, because the procedural timetable is already established by the arbitral tribunal prior. It seems to me that most likely not, but although you do have considerations of efficiency, you may consider whether or not adding a new claim or adding or consolidating the proceedings would lead for this arbitration to unduly extend beyond the point it would be reasonable or cost efficient in the case at hand.
Yeah, what I would also comment on is that, sometimes this cost efficiency is something that you think that it will be in one way, and later it goes in a completely different way. So I was in an arbitration that parties tried to, the respondent tried to join the claim to another arbitration that was already going on, and alleging efficiency. And it was denied by the court, and so I was assigned to this new tribunal. And now this new arbitration finished in 1 year, and the other is still going on. So at the end, it was more cost effective for the party and efficient not to join the arbitration. So I understand that also, other than all the practical issues of the case, there's also a matter of, I don't know, a number of variables that can happen and just interfere in it. There's another question related to the Article 10 of the ICC rules. What is the legal effect when parties agree on other consolidation requirements? Is there agreement to suspend application of Article 10 of the ICC rules? Or is the parties' agreement on consolidation to be applied simultaneously to Article 10?
Please, Greg.
No, go ahead. I think you addressed this very well in your presentation.
I believe that this will depend on interpretation of the arbitration agreement between the parties. In the case at hand, we do not have a very clear indication on the arbitration agreement or whether or not the requirements should be met. All the requirements of both the arbitration agreement and the ICC rules should be met. So you can argue both ways, but it may be a situation where the parties decide that consolidation depends on only a few requirements. Whether or not this would be valid under the ICC rules, or whether or not the ICC would agree to administer these proceedings, is another question. But the parties could say so. In the case at hand, I believe you may argue on both instances. The arbitration agreement is not that close that you cannot argue for joint application of Article 41.5 and 10 of the ICC rules.
Greg, do you want to comment?
No,
Okay.
that really covers it perfectly well.
Okay. So there's one more. Practically speaking, if the tribunal were to reject the consolidation request, can the party requesting consolidation have recourse to the ICC court to request consolidation under Article 10?
It is my understanding that most likely no. If we conclude that it is for the arbitral tribunal to decide on the matter of consolidation, most likely the ICC court will not go back and review the decision of the arbitral tribunal. As a matter of fact, the ICC also has a standing that some of its own decisions are not to be reviewed by the arbitral tribunal, and when the arbitral tribunal may review the decisions of the ICC court, the ICC rule specifically states so. So I believe in the opposite direction. Most likely the ICC rules would, the ICC court would not review the decision of the arbitral tribunal whether or not consolidation was proper. So the position of the ICC most likely would come from an earlier stage, whether or not it is possible for the parties to derogate on this. But if it understands that it is possible, the parties agree that the arbitral tribunal would have the decision.
Yeah, I fully agree with that. To me, this is a completely binary situation. Leaving aside the question whether it is possible to opt out, but assuming in this specific case and a specific arbitration agreement, etc., it is possible, then it becomes the arbitral tribunal to take this decision and not the court. And a review by the Court of Arbitral Tribunal's decision is, in this specific case, clearly outside of the ambit of the rules, but also as a general matter. The court does not review arbitral tribunal's decision because, frankly, that is not its mandate. To some extent, it obviously comments on arbitral tribunal's determinations when it performs the scrutiny, but as well, this is not a review. Even in the case of scrutiny, it remains the award of the arbitral tribunal. The court may decide whether to approve or not approve, but in the end, the court will never have the authority to tell an arbitral tribunal, even in the core point of ICC arbitration, one could say, the scrutiny to, no, you should turn left or to right. So to me, this is very clear that this would apply as well here.
Well, I think we still have some other questions, but I'm afraid we reached our last minute of the webinar, and I just want to use this time to thank you again to Bernard, Alicja, and Greg. It was really important to have you here, Greg. I know the difficulty it is for you to be speaking and not mixing that with the ICC position. I remind everyone about that. And I know the time of you all is very precious. And I thank you very much. I hope the students and arbitrators that will be taking part in the moot could get some insights here, some difficult questions to ask for the students, and the students some arguments to use. And I hope to see you in Vienna. Yes, thank you very much. And bye-bye.
Thank you very
Thank you
much.
so much.
And best of luck.
Next week, Eduardo.
Congratulations to the panel today. Next week. See you next week.
Thank you.
See you.
Thank you. Thank you. Bye-bye.
Thank you.
Bye-bye.